I&N's student. I&N student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us law student Arpita Tiwari. She is going to deliver a lecture on the topic of I.B.C, Corporate Insolvency Resolution Process. She is from KES Shri Jayantilal Patel College of Law. So without wasting further time, I would request Arpita to commence with her lecture. Thank you.
Greetings of the day. I, Arpita Tiwari, will give you a lecture on the topic that is C.I.R.P, that is Corporate Insolvency Resolution Process, which is governed under I.B.C, which is Insolvency and Bankruptcy Code 2016. Now there are two terms, that is insolvency and bankruptcy. What is insolvency and bankruptcy? Insolvency means it is a financial state where a person cannot meet a debt payment on time. And bankruptcy means it is a legal process that happens when the individual declares he or she can no longer pay back his or her debt to the creditor. Now, Insolvency and Bankruptcy Code 2016 has emerged lately to India because earlier there were codes, there were legislation, there were provisions in India, but they were inconsistent. There were no time-bound manner framework earlier. Hence, there were no provision to tell the authority to solve the matter within time limit. Hence, the present code, that is Insolvency and Bankruptcy Code 2016 came into existence. India's comprehensive legal framework for resolving insolvency and bankruptcy issue for both corporate entities and individuals. The code was introduced to streamline and modernize the process of insolvency resolution, replacing the patchwork of outdated laws and were insufficient and inconsistent. Now, who can initiate C.I.R.P, that is Corporate Insolvency Resolution Process? There are creditors. Suppose for an example, I am a company. I have to make a product. It could be any of the product which I want to make. Now, I have to take a loan from individuals or corporate entities. Now, for taking loan, the one who is giving me the loan, that person will be the financial creditor, and I being the company, I will be a corporate debtor. I own a debt of a financial creditor. Now there will be a person, I don't want money, but I need some product. I need some employee. For that person, there is another person, wherein I ask him to give me the raw material, to give me the employee, workman, force. That person will be my operational creditor and not the financial creditor. Now these two individuals or the entities, if I fail to repay them as to pay the salary of the employee, if I fail to do so, they will be the operational creditor. If I fail to give back the loan along with the interest, then the financial creditor. Then both entities can file an application to initiate, that is corporate insolvency resolution process against me. The financial creditor can submit and file the application under section 7 of the Insolvency and Bankruptcy Code, whereas the operational creditor under section 9 of I.B.C can file an application to initiate C.I.R.P against me. There is also one provision in the I.B.C wherein under section 10 of the I.B.C, I myself can initiate the proceeding of C.I.R.P against myself, so that if I make any default, irrespective of financial creditor or the operational creditor, I myself can approach the court that I have made the defaults and I cannot repay the amount or the debt owned by me. Hence, there are three provisions, that is section 7 under which the financial creditor can file an application, under section 9 where an operational creditor can file an application, and under section 10 wherein I myself can initiate C.I.R.P against myself. Now let us understand what happens and what is the next step where the application is being accepted. We have to understand first the adjudicating authority of the I.B.C or where the application should be submitted. The NCLT, that is National Company Law Tribunal, is the very adjudicating authority of this provision. Financial creditor, operational creditor, or the corporate debtor himself can file the application to the NCLT. If someone is aggrieved by the decision of NCLT, they can approach to the appellate tribunal, that is NCLAT. If someone is aggrieved by the decision of the NCLAT, they can approach the Supreme Court under section 62 of I.B.C, that is Insolvency and Bankruptcy Code 2016. Once the NCLT is agreed and satisfied with the fact that yes, there is a default, the corporate debtor failed to repay the amount, now NCLT will accept the application, and from the very day when the application is being accepted, over that time the moratorium period starts. Moratorium period is given under section 14 of Insolvency and Bankruptcy Code. What is moratorium period? Moratorium period is also, we can say in a simple language, it's a cool down period or a calm period, wherein the corporate debtor will be free from any of the proceedings which is going on in the other courts. The purpose of the moratorium period is to provide the corporate debtor with relief from legal pressure, allowing for a focus on resolution. Now, once the moratorium period starts under section 14 of the I.B.C, now NCLT will appoint I.R.P. What is I.R.P? It is Interim Resolution Professional. He is the one who will now look into all the matters of resolutions. Now, such as, now there should be a public announcement in the newspaper stating that if anyone has given any sort of loan, money or work force to the corporate debtor, for an example, if I fail to repay the money to the financial creditor, it is not always compulsory that there is only one financial creditor. There can be multiple financial creditors from whom I would have taken the loan. So for giving them the awareness that yes, this person has failed to repay the dues, now he is undergoing C.I.R.P. Hence, this is a notification in the newspaper that anybody having a claim against this corporate debtor can come and meet the I.R.P. Now, this is very compulsory for the I.R.P. to publish in the newspaper so that there should be an awareness throughout, so that it should not be any creditor to whom he is unaware and he remains unpaid. Now, once all the claim has come to the I.R.P. that yes, I have given the loan to him and here with the proof and evidences. Now, the next step is to form a COC. COC means Committee of Creditors. In Committee of Creditors, there are different amount of voting shares is been divided as per the loan amount which is owned by each of the creditors. After the COC is being formed by the I.R.P, now it is upon the COC, that is Committee of Creditors, to select the I.R.P should become the R.P now or they want to change the R.P. I.R.P means Interim Resolution Professional, whereas R.P is Resolution Professional. I.R.P is for initial stage, whereas R.P is for further or advanced stage. The COC in its first meeting can either confirm the I.R.P as a resolution process or appoint a new R.P. What is the role of the R.P? R.P, that is Resolution Professional. The RP is responsible for running the C.I.R.P, managing the corporate debtors operation and inviting resolution plans. There are resolution plans wherein the fees of the resolution professionals, fees to the adjudicating authority, and there should be all claims should get as much equal amount of their debt is owed. There is plan has been created by the applicants only or the COC members. Now, if the plan is good or it is approved by COC, it needs at least 66 of voting share. Once it is approved by the COC, it goes to the NCLT. If NCLT approves the same, then the resolution plan is executed. Now, the timeline of the C.I.R.P, the basic, essential and the aims and objectives of the I.B.C is the time-bound manner resolution. The timeline of the C.I.R.P process is 180 days and which can be extended to plus 90 days. It is the responsibility of I.R.P and R.P to complete the whole C.I.R.P process within the time-bound manner, so that just in case now the resolution plan is not accepted by the COC or been rejected by the NCLT, then the corporate debtor enters into a liquidation. What is liquidation? Liquidation is something wherein the assets of the corporate debtor is being sold out. Sold out so that whatever the amount is been received after selling the assets of the corporate debtor, that money can be used to compensate or to repay the creditors, irrespective of financial creditor or the corporate debtor, operational creditor. Now, the liquidation process is being done by the liquidator. Liquidator is appointed by the adjudicating authority, that is NCLT. Now we have to understand the scope and the ambit of section 7 of Insolvency and Bankruptcy Code 2016. Section 7 tells that wherein the financial creditor can file an application for initiation of C.I.R.P. Over there, the words are, if there is a financial debt existing, then financial creditor can file an application. But the words of the section says that the adjudicating authority may accept the application. Now over here, the question remains that there is a default. There is a default existing on the paper with proof and evidences. Still NCLT can reject the application, though there are findings that there are defaults. There is a landmark judgment of Vidarbha Limited versus Axis Bank Limited, wherein Vidarbha took loan from Axis Bank. Vidarbha paid all the EMIs along with interest duly, timely. But after a few years, he failed to repay the loan along with, as per the EMI. So Axis Bank gave him the notices. But irrespective, there were failure to repay the loan. Axis Bank moved to NCLT under section 7 because here the bank has given the loan along with the interest. So bank is a financial creditor and Vidarbha is the corporate debtor in the present case. The bank approached the court along with all the paper evidences that look, here the default has occurred and I am in the loss being a public sector bank. There should be initiation of C.I.R.P. and being the financial creditor, I request that you accept the application. Now here the NCLT looked into the facts and the circumstances of Vidarbha. After paying all the loans time to time for so many years and suddenly he is not paying the loans. Then the facts came that he was expecting that there was an order in favor of Vidarbha that he would get a refund from a government authority in future and hence his money was stuck. When he will receive the money, then only he will able to pay back the Axis Bank. But the fact here is Axis Bank is still in the loss. The Vidarbha will get the money after 1 year. Then what about the bank? Will he stay in loss for 1 year? The NCLT stated that though I have a discretionary power under section 7 that I can accept the application or reject the matter. But there is a default. I accept that as well. But I also have to see, for the sake of principle of justice, that he is a person who will pay you. And he is not into a default in such a way that he cannot pay. He is a financially stable company. And he is expecting the refund from a government authority, that is DOT, that is Department of Telecommunication. Hence NCLT said that I will not accept the application. The Axis Bank approached the NCLAT. NCLAT stated that NCLAT upheld the judgment of the NCLT. Now Axis Bank moved to Supreme Court. Now over here, the basic element and the aim and objective of the I.B.C. is the time limit, completion of insolvency and resolution process. The corporate insolvency resolution process shall be completed within the period of 180 days, which can be extended to plus 90 days. But here, the corporate debtor has not paid the due for more than a year. Still, NCLT, NCLAT and Supreme Court is not accepting the application under section 7. So here we understand that though the code is giving us the time-bound manner that C.I.R.P should commence, and there, if you are into the capacity of financial creditor, that you can file an application and NCLT will accept it. It is not in such a manner in actual case or the practical on ground level. There is always an exception that if there is a fact and circumstances which is stating something else which is not mentioned in the code, that can also be happened. Now, the objectives of the I.B.C. can be stated in three folds. That is, first, it focuses on the resolution of insolvency, which involves in finding a viable solution for distressed entity. I, being a corporate debtor, I cannot repay the loan of the creditors. I myself can approach the NCLT stating that I under section 10 that I cannot pay the loans or the dues or the debt I have owned. So it is a helping tool for the corporate debtor, and the main objective of this code is ongoing process, ongoing concern, that it is for the sake of the company and the creditors are the secondary objectives or the priority of this very code. Now the second objective is to aim the maximization of value of assets of the corporate debtor, ensuring that creditors can recover as much as possible. For an example, if a company is going under liquidation, now it is the focus and the main objective of this very code is that the asset should be sold and the recovery of the money is as much as possible, so that all the creditors should be compensated. It is also be possible that they are not getting the full amount which they have given the loan, but it is the primary goal and the expectation of this code is that there should be justice to all the creditors of the corporate debtors. Third, it seeks to promote entrepreneurship, ensuring availability of credit, the balance, the interest of stakeholders, including altering the traditional order of priority for the payment of the government dues. Now when the C.I.R.P happens, the resolution process is coming to an end. The resolution plan should always should consist of the government dues, the fees of the adjudicating authority and the fees of the resolution professional. In essence, the I.B.C. represent a shift in the balance of power in insolvency proceedings, moving from debtor-centric approach to one that empowers creditors. By doing so, it has introduced a greater sense of fiscal of and credit discipline, which is essential for maintaining economic stability and fostering a mature market economy in India. The courts market driven predictable and time-bound approach has made the cornerstone of India's economic reform. The corporate insolvency and resolution process of 2016 is a structured and time-bound process designed to resolve the insolvency of the corporate debtor. Hence, it is also being said that NCLT is not a debt recovery tribunal wherein all can come stating that I have not been paid by the debtor. So it is not a debt recovery tribunal, but it is an NCLT where the main objective is for ongoing process, time-bound manner, having to look that there is a existing circumstances, facts. Even in an exception case, the NCLT adjudicating authority do look in the favor of the corporate debtor as well. Thank you.
Arpita, thank you very much. It was nice hearing the I.B.C code because it's a very recent law which has come in 2016.
Yes.
So it will get evolved over a period. It's because every law gets matured as it goes more and more, the years are passed.
Yes.
So you have nicely explained the basic procedures, how to make an application, how the application travels,
Yes.
and what are the objectives of it. So thank you very much. This is for